Well, good morning and welcome to the Maryland Public Service Commission's administrative meeting for July 10th, 2019. I guess our first order of business is to adopt the minutes from July 3rd. Is there a motion?
Mr. Chairman, I move the commission approve the minutes from the July 3rd administrative meeting.
All in favor?
Aye.
Opposed? Motion is adopted. Minutes are accepted, I should say. Great. Mr. Executive Secretary.
Mr. Chairman, we only have one item on the consent agenda this morning. Item 1 is DMS Energy LLC filed an application for a license to supply electricity or electric generation services in Maryland.
Are there any questions?
I do have a question.
We do have
If
questions.
Staff could indulge me. I apologize. Mr. Jang,
Good morning, Chairman, Commissioners. Michael Jang on behalf of staff.
I noted that the buck sheet says that there have been no complaints against the company in Maryland, but they're an energy consulting entity. Is that right?
Yes, I believe so.
But are they registered with us? Do we regulate them?
Not currently. The reason why
Go ahead.
they are on that database that staff uses to search for complaints is when a company applies to become a supplier, CAD will put them on that list.
Okay, when they apply to become a supplier, okay.
Yes. Or a broker.
But normally, any complaints prior to that would have been probably filed with the Consumer Affairs Division of the Attorney General's office, right?
Yes, I believe so.
Do we check there to see if there's any complaints?
No, we do not.
Okay, maybe we're probably okay here, this consent item agenda, I get it, but maybe in the future we could look, the staff could look there as well.
Okay.
See if we got any complaints.
Of course.
Very good, thank you.
Thank you. Commissioners have any other questions? If not, is there a motion?
Yes, Mr. Chairman. For item number 1 on the consent agenda, I would move that we grant the company a license to operate as an electricity supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff. That we direct the company to provide marketing materials specific to its Maryland operations to the Commission staff and Office of People's Counsel 30 days prior to utilization of the materials in Maryland, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Thank you. All in favor?
Aye.
Opposed? Motion is adopted.
First item on the administrative agenda, and the only item, is item number 2. It's DCT Telecom Group, Inc. MBS Holdings, Inc. filed a notice of the transfer of control of DCT Telecom Group, Inc. and a pro forma restructuring.
Good morning, Chairman, Commissioners. Kenneth Alpert on behalf of staff. This item addresses a filing by two individuals, referred to as the transferors, and MBS Holdings, Inc., the transferee, that notifies the Commission that transferors intend to transfer control of DCT Telecom Group to MBS Holdings. DCT provides resold inter-exchange telecommunications services in Maryland. As part of the transaction, each transferor will contribute 50% of the outstanding shares of capital stock of DCT to DCT Telecom Group Holdings, which is a newly formed corporation, a holding company. In exchange for the contribution of stock, each transferor will receive 50% of the outstanding shares of the capital stock of DCT Holdings. As a result, DCT will become a wholly owned subsidiary of DCT Holdings, and transferors will collectively hold all the outstanding capital stock of DCT through the transfer's ownership of DCT Holdings. DCT will then convert from a corporation to a limited liability company, an LLC. After this conversion, MBS Intermediate Holdings will then acquire all the outstanding membership interests of DCT. As a result of all this, DCT will become an indirect, wholly owned subsidiary of the transferee. MBS Intermediate Holdings is the direct owner of a Maryland public service company that operates as a telephone company, therefore a public service company under the Public Utilities Act. In applying the public utility provision that addresses a public services company's acquisition of stock in another public service company, a company that controls a public service company is deemed to be a public service company of the same class as the controlled public service company. Therefore, MBS Intermediate Holdings is deemed to be a telephone public service company. Because of the conversion to an LLC, the transaction involves the transfer to MBS Intermediate Holdings of the membership interests in DCT, not the transfer of DTC's stock, which is canceled due to the conversion. However, the conversion is an integral component of a single transaction in which ownership of DCT, that is a stock corporation, at the start of the transaction is transferred to MBS Intermediate Holdings. Therefore, the transaction should be viewed as the acquisition by a public service company, MBS Intermediate Holdings, of the capital stock of another Maryland public service company, DCT, that one operates in Maryland and is of the same class, a telephone company, as the acquiring company, which is MBS Intermediate Holdings. This means that the transaction requires commission authorization under Public Utilities Article 6-101C3. The transaction here will result in an acquisition that we believe is in the public interest. The parties assert that the transaction will provide additional capital and managerial resources to DCT. The parties assert that as a result of the transaction, the parties will, quote, benefit from the scope and scale efficiencies resulting from combined operations, which will in turn strengthen their respective competitive positions in the telecommunications market and enable them to more effectively serve their customers. Therefore, the staff believes that the transaction is in the public interest. Hence, staff recommends that the Commission approve the transaction.
Thank you, Mr. Albert. Are there any questions from commissioners? If not, is there a motion?
Actually, I do.
Oh, I apologize.
That's okay.
Commissioner Herman.
So, Mr. Albert, by approving this as opposed to noting the transaction, are we opening up the commission to having to approve many more similar type transactions?
Well, again, what's significant here is we see lots of transactions, this whole issue of an transfer of the ownership of an LLC. But here it's unusual because it's not at the beginning of the transaction, the target, DCT, is a stock corporation.
Mm-hmm.
So what we're doing here is just so if you look at each of the steps of this transaction individually, viewed totally in isolation, we would not have it fit within a jurisdictional bucket, because at that last stage where the transfer of ownership happens, it's an LLC, not a stock corporation.
Right.
However, it's part of a single transaction. So what we're dealing here is a special situation where the LLC conversion is part of a single transaction where, but for that conversion, this would be a jurisdictional transaction. And because it is part of a single transaction, our view is you look at this holistically and view it as something that would as a practical matter, is the transfer of the capital stock.
Right, but the reality is that it's they've structured it so that they become an LLC, and that therefore the commission wouldn't have jurisdiction. So let's say if the transaction becoming an LLC took place a week before the transaction, what position would you have at that point?
Well, thank you. I mean, that's exactly what we struggled with on this one. Here it was an easy case because it was all part and parcel, and it was presented to us as part and parcel of a single transaction that's happening essentially simultaneously. But I certainly appreciate your point that if the LLC conversion were to be a distinct event, happen in several months before, then we wouldn't be able to tie it to this acquisition unless. I mean, I can imagine a situation where we find that it essentially was a single transaction and they sort of timed it so that they could make the argument that, gee, that was a month ago. But here we have an easy case because it's presented to us as essentially a simultaneous transaction, albeit with, I think, roughly 4 or 5 separate steps. But as a practical matter, the ownership of a stock corporation is being transferred. So I appreciate we may have to cross that bridge in the future, but this case is sort of the easy case.
Right. So, Mr. Chairman, I think, I have some potential legal concerns with respect to this because, you potentially could be starting down a slippery slope where if somebody did it 5 minutes before or the day of, and that's all part of a single transaction. I understand your dilemma, Mr. Albert. So I'm kind of torn here because we have a rule that, if it's an LLC, it doesn't, we don't have jurisdiction over that. So I don't want to be grabbing jurisdiction over something that we that we shouldn't be taking. You know, I don't want to pick up jurisdiction that we don't have. So I understand your question and your concern. You're saying that here, that if we don't do it here, or are you saying that if we don't do it here, that somebody could structure a much larger, more significant transaction in this way, and to avoid jurisdiction? Is that what your concern is?
Yeah, that may well be. I mean, as a practical matter, given that these telco acquisitions usually go through, either being noted or in less frequent case, approved, where they fit in a jurisdictional bucket, I'm not sure there's much of an incentive to be, where people are concerned about structuring it so they don't come under commission review.
Right.
Having said that, that could happen. Changes can happen in marketplaces. And again, this applies specifically to all public service companies. We're talking now in the context in which this most frequently arises with telcos. But yeah, that could be a situation.
Right. Ms. Romine, did you have a comment?
Yes, thank you, Commissioner. I hear what you're saying, and we did have some concerns about this, basically along the lines of what you're talking about. And we're checking right now to see if it's feasible to push this, continue this matter, so we can take a better look at it, given your concerns, because we...
Yeah, I don't want to do something that's going to have an unintended consequence.
Absolutely.
And so, I don't want to hold these folks up, but I don't want to do something that has an unintended consequence that we're faced with, having to undo something down the road.
Right.
Ask, are
And
we setting some kind of a precedent with this, or can we just deal with this as a discrete?
Well, see, that's my concern, that if you come in and you say, well, this one, because it was, supposedly simultaneous was this case, but then somebody does it on the same day, and does that, so this is my concern. I don't want to do anything inadvertently that comes back later where we're faced with someone from the company saying, well, in this other case, they were an LLC and you didn't take jurisdiction, or you did take jurisdiction. So I'm just trying to make sure we're not.
And we have no representative for the company here today.
Yeah, so I'm just not.
Is there a time issue that we could maybe?
Is there a time issue?
As far as we're aware of, there is none. And I know I was unfortunately on vacation during the end result of this discussion, but I know that there's case law in other situations, such as in the real estate area, where they have is called a step doctrine, which basically addresses exactly what you're talking about, that might be helpful to the outcome of this. And based on that, if the commission's comfortable, if we could defer it for 2 weeks.
So deferral wouldn't have any consequences for the company then at this point. I guess we don't know. They're not here.
Not
so.
that we're aware of.
Okay. Well.
I would be comfortable with that.
Okay.
Yeah, I just want to make sure that we're not starting down a road we don't want to start down.
Understand and agree.
Okay. It sounds like we agree up here that we'll defer this to a future administrative meeting. So. Is that? I think that's all we need to do on that, right? There's no motion or anything, so great. With that, I think we've concluded all business, and we are adjourned.